Meeting number 180, and we are going to skip to item number 9B on the agenda. Deputy Director Lilios.
Good afternoon, Commissioners. We're here before you today with, green light is on. Green light, there's the green light. Good afternoon.
Good afternoon.
Here today with some emergency amendments to the licensing regulations. We were here in December with some emergency amendments, and we have fine-tuned them, and you have several provisions before you. We can start with the amendments to 205 CMR 134.12, the temporary licensing regulations. And that section is divided into two subsections. The first is for temporary licensing for employees, and the second is temporary licensing for vendors. And those two subsections are identical except for the terms for temporary licenses differ between employees and vendors. So the subsection A in each of them is required by statute, and that is that the gaming licensee or the casino has to petition us for a temporary license. And they can do that if the applicant for the license has filed completed forms. That's also required by statute. And if the casino certifies and we find that the issuance is necessary for the operation of the gaming establishment and is not going to circumvent the normal licensing procedures, that's required by statute. The portion that we have worked to fine-tune is the subsection B, and we have done that to create a presumption that the temporary license is going to issue. And another aspect of this fine-tuning is to emphasize the preliminary nature of the temporary investigation process. So this subsection B says that the temporary license shall issue unless the individual is disqualified under our regs, or the preliminary review of the application shows that the applicant will be unable to establish suitability under our regulations. And then the next subsection is the term of the license, which is 6 months with 1 6-month extension for employees or for vendors. On the following page is upon issuance or the temporary license is good unless for some reason we were to suspend it or withdraw it, but in any event, no longer than the initial term of a full license, which would be 3 years. So those are the changes on the temporary license regulation.
I have a question.
Sure.
So, it says that it's upon petition to the commission, the temporary license shall issue unless 1 or 2. Who makes that determination? The IEB?
Yes, the IEB, under a separate delegation, has the authority to make determinations on temporary licensure.
I should have this in front of me, but what, 134.10.3, do you have that in front of you?
I do.
Would you just read through
So
those?
the automatic disqualifiers are felony convictions or convictions for theft, embezzlement, perjury, or fraud. Another automatic disqualifier is an application that intentionally contains false or intentionally misleading information, committed prior acts that have not been prosecuted or led to a conviction but are a pattern of misconduct that makes the individual unsuitable, or the affiliates or close associates who would not qualify or pose an injurious threat to the Commonwealth in issuing the license.
Are those the statutory automatic disqualifiers?
Yes.
So it's nothing more than the statutory automatics?
That's right. The reg reflects the exact statutory language.
Okay.
In both of those subsections. Same for subsection 2 on the suitability factors. So moving forward to the terms of the licenses on 134.16, the only change there is something that you have seen before, and that is we are asking for the initial term for the key employee and gaming employee licenses to span 5 years instead of 3 years, and that is because otherwise we would be doing the renewals for all of the Penn employees at the timing of the projected opening of MGM and Wynn, so a changing of the initial term of those employee licenses. And the next regulation, the following two regulations talk about new qualifiers. One for new qualifiers for the casinos or the gaming licensees, and the other for our primary vendors. So 116.07 talks about new qualifiers for the gaming licensees, again, that would be our casinos, and this is a situation where one of our casinos gets a new qualifier, say a new inside director or a new CFO, and the prior reg stated that the new individual cannot perform any duties related to the new position until a positive determination on suitability issues. And that would hamper the ability of the casinos to get their work done. So the proposed language here is that the new qualifier can start working upon appointment and then has to get a full license application into us within 30 days of appointment. And that 30-day window is common practice in other jurisdiction. And can continue working until qualification, so long as they get the full application packet in. And if there's discussion with the licensing division in advance that they need additional time, that would be allowable generally under our regulations. And then the second subsection under this reg is an instance where the parent company may create a new position and it is not apparent that it's a qualifying position. This subsection requires the casino to let us know about the new position, and then we have the opportunity to designate or not designate that the position's a qualifying position. If we designate it as a qualifying position, the same procedure, the 30-day window procedure, follows.
Loretta?
Yes,
So that's section 11607, subsection 2.
that's right.
Is that how we're dealing with the notion that we discussed a little while ago about at the gaming establishment?
No, these are qualifiers typically for the parent company. At the gaming establishment, we're talking about another class of individuals who would be key employees. These are qualifiers for the parent company, a new general counsel, new CFO of Penn National, or so not our immediate licensees.
But is it fair to say that this may be a similar sort of process if the licensee believes that, I guess something that we could explore, put the onus on the licensee?
Sure, to reach out to us to have the conversation, is that what you mean? Sure, because if they don't reach out to us, we may not know in a timely way that they've created the new position.
Okay.
And then the final reg, which mirrors in large part the casino new qualifier reg, is a new qualifier reg for gaming vendors primary. And these are that subset of companies like Konami that was before you today. They all are used to a process like this when they have a new qualifier at the corporate level. They are used to following a protocol like a casino would of notification to the jurisdiction, like the 14 individuals that you reviewed for today. So a similar process for the primary vendors. We are not requiring this process of secondary vendors, the construction companies and so forth. We would deal with any changes in their corporate qualifiers in the regular license renewal process.
Was that subsection 3?
The vendor new qualifier is 134.04.
Oh, sorry. Thank you.
Any questions, issues, discussion? All right,
So the request is that we adopt these by emergency reg today, but also start the formal promulgation process so that the two processes can move in tandem.
You need a vote on each
We
section
need a
of
vote
the
on
law.
each. We need a
Can
vote
we-
on each.
oh, individual, or can we do them as one?
You could do them as one if you like. But you just need to list them
Yeah.
in your motion, but if you list them separately in your motion, and you can vote on them all together.
I move that the commission approve the proposed regulations as they appear at 134.047. I guess that'd be 205 CMR 134.047. 134.12, 1 sub 1, 2, and
And three.
well, 3 doesn't seem to be parenthesis. Is that a typo?
It might be easier to take them off the agenda. I
Right.
think
That's
the
what
numbers are
Commissioner Cameron just
listed.
gave me.
Oh, okay.
Yeah, I thought I was being helpful. All right, I propose that that we
So I'm gonna
approve,
Strike the earlier start.
strike the earlier motion and start all over again. I propose that we approve the recommended changes to the regulations, specifically draft regulation 205 CMR 134.12, draft regulation 205 CMR 134.16, draft regulation 205 CMR 134.047, and draft regulation 205 CMR 116.07
On an emergency basis.
on an emergency basis.
Second.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Do we need another motion for the?
If we can also move to let us take them through the final formal promulgation process, that would be helpful as well.
You want to roll, Commissioner?
So moved.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
All right, now we are back to item 6, General Counsel Blue.
Commissioners, as we decided last year, we determined that in March of each year, we would elect a secretary and a treasurer for the commission. As you have done in prior years, that requires the commission to nominate one of its own to be the secretary and one of its own to be the treasurer, and then vote to have them take on that role for the upcoming year. So if you could make your nominations and your vote, that would be appreciated.
I would move to nominate Commissioner McDonald as Secretary of the Commission for the year beginning March 2016.
Second?
Second.
Is there discussion?
I think we should have a debate, a primary.
Yeah, I think so,
couple
too.
This might
caucuses.
be the shortest the campaign.
Is there anything about his ears that you want to say, or?
There might be some lessons learned here by how easily we're doing this.
Any other discussion? All in favor?
Aye.
Opposed? There's one abstention, I
Abstention.
believe. But an abstention by Commissioner McDonald, but otherwise an exuberant and unanimous vote.
Thank you, colleagues.
Do we have another motion?
Mr. Chair, I'd move that the commission nominate Commissioner Zuniga to serve as the commission's treasurer for the year beginning in March 2016.
Second?
Any discussion? All in favor?
Aye.
Opposed? The extension by Commissioner Zuniga, otherwise an exuberant and unanimous, a positive vote.
Thank you, Commissioner.
Any victory speeches you'd like to give?
Yeah.
We'll gladly continue to do the work that we did.
Thank you to my family, all of those volunteers who held signs. Okay.
The next item is Ombudsman Ziemba, who will discuss the process and the timing on the WIN Section 61s.
Thank you. Mr. Chairman and Commissioners, today we provide a brief status of our draft and a review process for the so-called Section 61 findings required under the Massachusetts Environmental Policy Act, MEPA, for the proposed wind project in Everett. As you're aware, on August 28, 2015, the Secretary of Energy and Environmental Affairs determined that WIN's second supplemental final environmental impact report adequately and properly complied with MEPA. In the certificate issued by the Secretary required enhanced public review during the development of Section 61 findings by both the Massachusetts Department of Transportation and by the Gaming Commission. Included within the mandated enhanced review were the publication of draft Section 61 findings by MassDOT for public review and comment, and a 15-day comment period. This 15th day of comment period was February 25th. MassDOT is also required to have a public hearing on the draft findings. This hearing is scheduled for next week, March 10th. Following the hearing, the certificate states that MassDOT will publish final Section 61 findings no later than 40 days after the initial filing. This 40th day will occur by the 22nd of March. The Secretary also required an enhanced process by the Gaming Commission. Under that, the Commission shall consider and revise as appropriate draft Section 61 findings included in the SSFEIR. MGC, Section 61 findings shall include or include by reference Section 61 findings from all other state agencies included, but not limited to, MassDOT Section 61 findings. A consultant hired by the MGC will make a public presentation at an MGC meeting and provide recommendations regarding additional conditions that should be added to the draft Section 61 findings. MGC will solicit written comments on the draft Section 61 findings and will hold a public hearing. The draft Section 61 findings and the consultant reports will be posted on the MGC website. Final Section 61 findings will be incorporated into the gaming license and will be filed with the MEPA office. And then compliance with the Section 61 findings and the conditions of the gaming license will be part of a regular quarterly report review conducted by the MGC. This is a significant internal and external review process that has been underway internally for months. We recommend that we now initiate the public review portion of the review process and offer the following potential dates for the items I just discussed. We believe that we could have the consultant presentation at our next meeting on March 17th. If the commission is comfortable regarding the draft presented and any additional conditions that may be offered by the commission would then ask for written comments. A public hearing could be scheduled potentially for March 28th. This hearing would come after the scheduled release of MassDOT's final Section 61 findings scheduled for March 22nd. It is anticipated that any commission review of final Section 61 findings would not occur earlier than the second week of April 11th to the 15th that week. The commission has a regularly scheduled meeting on the 14th of April. Early next week, staff and commission consultants will meet to determine the latest status of our review, taking into account any of the comments that were submitted during the MassDOT process. Assuming that we are all ready, we could then issue a release or blog outlining these proposed dates that I just mentioned to you. The proposed schedule should give us time to receive and review comments. We do note that the commission is free to make adjustments to such a schedule if deemed necessary or circumstances warrant. One further option that we have is to post a pre-commission review draft if one is ready before the 17th. So before the consultants present to the commission, potentially what we could do is post a version of the draft Section 61 findings pre the commission review. And the benefit of this is that it could provide additional opportunity for comment by the public. If the commission thinks this review process to be a good one, and the optional early draft preview to be warranted, we could work with Executive Director Bedrosian to firm up the schedule and to make any postings. Again, we can adapt to circumstances or any issues that require further review.
Questions?
So by posting early, we'd have the benefit of hearing or reading comments at the time of our review. Is that?
Perhaps. I mean, it is a short window, so I'm not sure how many comments we would get in that period. So it's an option. It depends on how quickly we can get the draft ready for presentation. But in essence, we're talking about an extra few days to do so.
And if we didn't do that, if on your proposed schedule, the public comment period would run from when to when?
So in essence, it would run from the 17th. It would run through the public hearing on the 28th. We could receive comments for at least a week after the 28th in advance of the second week of April.
Right. So there's quite a bit of time in any event.
Yeah, and we also benefit obviously from the MassDOT Section 61 findings,
Right.
the predominant issue, and these findings are transportation related. There's a hearing. We'll take a look at those comments, and we'll attend the hearing to monitor comments.
Plus, this has been open for the interested parties have been tracking this
For months.
daily, yeah, for a long, long time.
That's correct.
Yeah, I think if we posted the draft to ours, I don't know, a couple of days prior to the consultant's presentation, that may be of some help. If somebody's looking attentively to those drafts, to those findings, and then listens to the consultant's presentation, there may be, the ability to confirm or
Right.
whatnot. But beyond that, excuse me, small window of benefiting from the presentation, I don't think that, makes sense to try to publish them a lot sooner than that.
I don't think it makes very much difference, frankly, one way or the other, but I think our tradition has been pretty firm that we have things reviewed preliminarily by the commission first, and then invite public comment, and then we have another review by the commission. So for consistency's sake,
We do that too.
yeah, as I said, I don't feel strongly one way or the other, but I think that's been our pattern. It's an important pattern that we not do less than that, and maybe it's worth sticking to that as a model.
I think that makes sense. I question whether we would get much of value from public comments prior to our consultants' publicly accessible recommendations, and my hunch would be that that's what's going to trigger substantive comments of a significant sort from the public.
So I guess, is the commission comfortable with that proposed schedule?
Looks like we are.
I am, yep.
Yes.
Right.
Yes. Thank you.
Okay, thank you.
Thank you.
Is that it? On that one?
That is.
On item 6C, the Mohegan Sun litigation, about a month or so ago, I updated the commission on the status of the various litigation
Is your
matters.
mic on?
Yes.
Okay.
Arising out of the commission's decision to award the Region A license to Wynn. At that time, we discussed the judge's decision dismissing Boston Revere, the IBEW, in the open meeting law litigation, while allowing Mohegan Sun to pursue a certiorari claim going forward. Mohegan Sun's certiorari claim is proceeding. There's a conference with the judge on April 1st. As part of Mohegan Sun's claim, Mohegan Sun has asked the judge, and this has been going on for some time, for the ability to expand the record that the judge will consider. And by expanding it, what they would like to do is add documents that they believe were considered by the commission when they made their decision. As part of their request to expand the record, the Commission's counsel and Mohegan's counsel have agreed to what's known as a protective order. That means any documents that would be released subject to that protective order would have varying levels of protection in terms of who could see them. So this particular protective order has 3 levels. One is that the Mohegan's attorneys and their consultants and the Mohegan clients can see them. One is just the attorneys and the consultants, and then there's one called attorney's eyes only, where only the Mohegan counsel can see the documents. Mohegan has requested that, in particular, that the documents submitted to the commission as part of the RFA-1 and RFA-2 applications be added to the record in unredacted form. The commission has already provided those documents in redacted form as part of the record. Under our regulation 205 CMR 103, if the commission has granted confidential treatment to documents and later determines that changed circumstances make it appropriate for the commission to reconsider and possibly modify the grant of confidentiality, the commission must notify the owner of the confidential documents, give the owner a reasonable time to substantiate keeping the documents confidential, and then after they receive that response, the commission receives that response, the commission shall make a new determination regarding the confidential treatment of those records. The judge has incorporated that regulation into the protective orders. We informed the judge that we thought we needed to follow our regulations first before considering Mohegan's request. Wynn is aware that Mohegan has requested these documents, and we at the commission and our counsel have asked Wynn and Mohegan to meet to see if they can work out some of these matters between themselves, and they have indicated that they will try to do that. If they can't work out an agreement, however, the commission will need to make a determination as to whether confidential treatment is still merited by the documents that are in question. And the documents in question, the vast majority of them are attachments to the RFA-2 application that Wynn submitted. So this involves several hundred pages of documents that will require review, and we have had some review by the legal department and outside counsel and others. So what I'm asking the commission today would be to delegate authority to me and to the executive director to review the documents and make the determinations as to whether confidential treatment should still attach. One of the things I think it's important to remember is when we drafted our regulation, we were much more concerned about public records, and we have an exemption from the public records law for these kinds of materials. This is a different situation. This is part of litigation, and it's also under a protective order. So the documents are not to be publicly released, but this is to release them to the other party in the litigation. But in the event that a determination is made that these records should no longer be confidential and should be released under the protective order, Wynn will still have the ability to go into court and challenge whether they should be released or not. So this is
Released even under the confidential
yes,
structure, yeah.
yes.
Released
And
at all.
That's right. So this is just the first step. This is the commission complying with a request that's part of the litigation. But Wynn, who is the best advocate, obviously, for their materials, will have the ability to go before the judge and make their case there. So there's still more opportunity to have their position considered. So that's the matter before you today is a request for a delegation of the ability for me and for Executive Director Bedrosian to look at the documents and make the determination, and then work with outside counsel to take it forward.
I would also note, Commissioners, that General Counsel Blue and I sat with Commissioner McDonald on this issue, as he is uniquely qualified, I would suggest, given his past experience in similar type areas, and had this conversation with him also.
Right, I was going to share that with my fellow commissioners, that I do meet on a weekly basis with General Counsel Blue on whatever issues of a legal nature are in need of discussion, and this issue and the prospect of it coming before the commission was a subject that we discussed at some length, and Mr. Bedrosian was there as well, as he usually is in that weekly meeting. I do think it's appropriate for me as a person with a legal background and a judicial background to be involved on this before a decision is made, and accordingly, that General Counsel Blue made available to me all of the files that had been submitted, files and documents that had been submitted by Wynn, along with the spreadsheet in which either she or our counsel had identified all of the documents that were at issue here, and which also indicated those to which there was no objection to their being released, and those to which there was a modified objection to their being released, namely there would be a restriction to counsel reviewing them and parties, if I recall right. And then the final, the third category would be attorney's eyes only release conditions, and then the final category would be to take the position that they not be released at all, and to leave to the judge to resolve that issue. With that spreadsheet in hand, I then did a roughly random sample of these documents, and they are familiar types of issues were posed by the documents. Many of them having to do with alleged proprietary business practices and information. My understanding, and Counsel Blue, correct me if I'm wrong, that staff's recommendation with regard to these documents would be that the ones which are the ones which are most sensitive, that they be permitted to be released, but subject to attorney's eyes only. There would be a relatively small number of those, and the expectation would be that if Wynn objected to that, then Wynn's attorneys could take that to the judge, and then she would, after a hearing, make a final decision as to whether they are released or not, and thus whether or not the documents in fact contain information that a reasonable person would think would compromise the legitimate business privacy and trade secret interests of Wynn. I will share with you that I'm completely comfortable, with that process, and having done my sampling of the documents, I concluded that it was unnecessary to go through each and every one of these documents and the voluminous material submitted by Wynn, and it would be my recommendation that we adopt the proposal of General Counsel Blue in this regard.
Okay?
I certainly would base my judgment on Commissioner McDonald's review, and am comfortable as well with that delegation.
Anybody else?
No.
Commissioner Donald, do you want to make a motion? Offer a motion?
I'll give it a try. I move that the commission, approve the motion or the recommendation of General Counsel Blue with regard to the release of the documents that are at issue in the Mohegan Sun litigation, and the recommended process for the commission's determination of confidential documents, as has been described by General Counsel Blue.
Second?
Second.
Yep.
Further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you. Next on our list, we have two small business impact statements. We're beginning the formal promulgation process for amendments to 205 CMR 152, individuals excluded from a gaming establishment. As you may recall, this is the regulation that creates the excluded persons list. I know I always get it confused with the voluntary self-exclusion list, but this is the one that we brought some amendments before you, I think, a meeting or two ago. So if we approve the small business impact statement, we can move that forward for its hearing and then final promulgation. And we also have the small business impact statement for the changes we made for the voluntary self-exclusion. Those were changes that we made after a review of that process and after the commission asked us to clarify that. So this is the small business impact statement for 205 CMR 133. So we can vote on those together too, as long as we mention each one separately.
So, Mr. Chair, I move that we approve the Small Business Impact Statement 205 CMR 152, individuals excluded from the gaming establishment, as well as Small Business Impact Statement 205 CMR 133, voluntary self-exclusion.
Second?
Second.
Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
And that's it with item 6. We didn't go back to Ombudsman Ziemba.
Thank you, Mr. Chairman, Commissioners. Thank you, Mr. Chairman, Commissioners. I've included a summary of applications the Commission received for funding under the 2016 Community Mitigation Fund in your packet. Our 2016 guidelines note that the Commission expects to make decisions on these applications by July. Perhaps we could make decisions earlier, perhaps maybe even by May. As a review is still ahead of us, I don't plan to go over the details of these applications today. However, I do ask the Commission to give approval of 2 items. First, I ask the Commission to establish $100,000 reserves for 8 communities, 4 communities initially eligible in 2015, including Attleboro, North Attleboro, Hamden, and Melrose, and 4 new communities, the 3 host communities, Everett, Springfield, and Plainville, and Revere. After the reserves are authorized, my office will work with the communities to determine the use of these dollars, either for planning purposes or for a specifically identified impact. Once such purpose is determined and an application is ready, we'll bring the application back to the Commission for approval. The second item I ask approval for is a grant to the City of Springfield of $350,000 for the Springfield Historic Preservation Trust. This is actually not a reserve application. This is a specific impact application under our guidelines. As you're aware, the Commission entered into an agreement with the Mass Historical Commission, MGM, the City of Springfield, the Springfield Historical Commission, and the Springfield Preservation Trust for the creation of this reserve. The Commission, in that agreement, provided that it would pay $350,000 to the fund, and that would be matched by $350,000 from MGM. Following your approval, if so granted, staff would execute a grants agreement with the City of Springfield, and then we would disperse the funds. We have an April 30th deadline pursuant to the agreement that we reached last year. One note, in order to be in compliance with our guidelines, Springfield has agreed to be the co-applicant to the application that was submitted by the Springfield Redevelopment Authority. With that as a background, I ask for your approval of these items.
John, remind us which ones are rollovers from last year that were not on you?
4 rollovers are Attleboro, North Attleboro, Hamden, and Melrose. And so we authorized those 4 communities in the 2015 guidelines. Those 4 communities either by reason of lateness in filing the application or because they never got the application in, we preserved their reserve into this year. Mm-hmm. And then the other 4, Springfield, Everett, Plainville, and Revere, those are all newly created. We determined that we would make funds available when we created the 2016 mitigation guidelines in December.
Very good. And of
For a
course-
motion?
Yep, I'll be happy to move that the commission approve the Community Mitigation Fund Reserve applications for, as outlined in the packet here, for the communities of Attleboro, Everett, Hamden, Melrose, North Attleboro, Plainville, Revere, Springfield, for a reserve, for a planning reserve, and Springfield for the preservation trust purposes described by.
Commissioner, if we
here.
could just note for the record that that final one is a
Reserve.
a
It's
specific
not a
impact
reserve,
grant,
sorry.
not a reserve.
Sorry. Strike that
That should be
then.
a separate motion.
Yeah, that'll be a separate motion. Then only one Springfield reserve in this motion.
Second?
Second.
With the discussion, so all these, the rest of the stuff in the packet with these applications, we're not discussing at this point, right?
No, we have to do our reviews,
okay,
which
right.
can be rather comprehensive.
Right. Further, any discussion? All in favor of the 8 requested reserves signify by saying aye.
Aye.
Opposed? The ayes have it unanimously.
John, I have a question on the second grant. Talking about the grant contract by which you're going to be able to distribute the funds. As part of the conditions of that grant contract, can we put in some type of reporting requirement as to how these funds are expended?
Yes, yeah. We've discussed
We've
that
done
with Derek.
Mr. Chairman, I would move that the commission approve one-time grant from the Community Mitigation Fund in the amount of $350,000 to the Springfield Historic Preservation Trust Fund.
Second.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Thank you.
Thank you.
So we have left, I think, Racing Division?
And then I think we have one matter, 9A.
Right.
Good afternoon.
Good afternoon.
Today, we're bringing back in front of you the changes that have been proposed to the Racehorse Development Fund. We've concluded the informal comment period, and Catherine Blue has incorporated some of those changes, and we'll also be discussing the small business impact statement. Catherine?
So what you have in your packet today is a small business impact statement for the amendments to 205 CMR 149, and you have the final draft of the amendments to that regulation. This draft is essentially the same as the draft that was before you previously, with the exception of the last paragraph, which I deleted. And I deleted that in response to a comment. We did receive a comment that thought it would be inappropriate for a commissioner to be representing the viewpoints of another group besides the commission. I think a commissioner who's on the horse racing committee will be representing the viewpoints of the commission as well as all of the stakeholders, but I think it rendered that language unnecessary. So the final version that we'll put out for promulgation will not have that last paragraph that you will see as stricken in your draft. Once we approve these amendments and we approve the small business impact statement, we'll be taking this through the formal process. There will be a hearing, and there'll be time for more comments, the formal comment period too. And I think just for the benefit of our audience, we got a lot of comments, I'm sure the commission has seen them, about the concept of the recognition of a horseman's group. And I think based upon the conversation we had earlier, or later last year, but a couple months ago, the purpose of these amendments really is to get purse money out to as many people who can race as possible. It really was not designed to talk about recognizing a horseman's group. It is, we are not required to do that by our statute, but it is designed to make the maximum purse money available. So if we have multiple racetracks and multiple meets, we want to make sure we can get the purse money out there. So that's what these amendments are designed to do.
I have a question on the last amendment. It's 14904 subsection 4 3C? Yeah, it's 3C. Anyway, where the commission may distribute less than the entire amount of the funds if the commission determines in its sole discretion that such distribution shall be beneficial. What if there are two or more with requests that is in excess of what's available? When you add them together, then the amount is in excess of what's available for the year
Under the fund.
under the fund.
So if, first of all, if the amount is in excess of what's available, whatever the excess is.
We cannot
can't-
distribute anything.
The purpose of this section was to allow the commission to not grant the entire amount if the commission wasn't comfortable. It in essence codifies what you did last year when Suffolk came in. So I think what, this gives the commission the discretion to determine how much should go to each individual meet and in what amounts. And you might want to consider things like number of days raced or number of races on each card. You know, what would be an equitable distribution? So this gives you flexibility in terms of awarding it. I think
Yeah.
in the situation that you've mentioned, if there was two of them and they added, let's say they added up to the total, you would probably want to take a look at what they were doing. Were they full races, full season, shortened seasons? You know, what that looked like and how much per race would go out.
It's just that the way that the language is structured, I would have thought about it the other way, as in, if it's determined that it's beneficial to do so, but no, unless we determine that, we may distribute such amounts as we agree would be beneficial.
If you would like us to change the language around, we certainly can. Before we
Okay.
do it for formal promulgation, we could do that.
But do we need to do this, is there a time frame to start this promulgation process that you already counted on?
No, I mean, we were going to start it now. We did put it out for informal comment, which was very helpful. So whenever we are ready to start it, we would like to get it out there about the time the meets start, but we also know that the thoroughbred meets are starting later. The harness meets start in April, but the harness side is in a little better shape at the moment, so.
But this is the beginning of the formal process, right?
It's the beginning of the
This-
formal
yeah.
process, yes.
Then I'm okay with that.
Okay.
Yes.
There's a chance to go back.
There's a chance to just tweak it a little.
There is, and we'll get a lot more comments,
Right.
and there's time to make changes in it before it becomes final, so yes.
All right. Do we have a motion, Commissioner?
Yep, Mr. Chair, I move that we approve 149.00 Horse Race Development Fund for formal promulgation,
And if we could approve the small business impact statement too?
and add the small business impact statement approval for promulgation as well.
Second?
Second.
Discussion?
This is one of the few small business impact statements where there is an impact, as we
There is, yes.
there will
This is
likely
one.
be an impact because some of these are small businesses, right? Some of these horse people.
A lot of them, the owners and trainers, yes. Most of
Yep.
them probably are.
Further discussion? All in favor?
Aye.
Aye. Opposed? The ayes have it unanimously.
Thank you.
All right.
Thank you.
Thanks, Thank you.
Thank
All
you,
right.
Director.
Last but not least, Director Wells returns.
Here with props. Okay, 9A. They went with your version?
Thanks, Lee. Mr. Chairman, Commissioners, I'm here today to introduce you to the IEB's Fair Deal Tip Program. It should be noted that there's always on our website, the public's had the ability to send us a tip of some kind, but it's just not structured as well. Before I start, I'd like to acknowledge gaming agent Louis Lozano, who suggested this, that we put this program together. And I'd like to encourage that kind of thinking amongst the staff. Fair Deal is a part of a comprehensive effort to ensure integrity of the state's gaming industry. This program will offer several convenient ways for patrons, gaming employees, and/or members of the public to provide helpful information directly to the IAB. A tip program provides the public with an organized and specific method to directly contact the IAB with any potential concerns or personal knowledge of unethical or non-compliant gaming activity. Fair Deal allows tipsters to provide information via telephone, online report, or email. To educate the public of the program, we're going to generate increased awareness of this program. The Massachusetts Gaming Commission will execute a comprehensive communications campaign through a combination of marketing, traditional media, outreach, and try to use the maximum of the newest technologies available, including social media. This would not have moved forward without the hard work of Elaine Driscoll, Mike Sanguin, and Dan McDonald. Thank you for your hard work. Got any questions?
Question, sir.
Yes?
I know tip lines, one of the challenges can be staffing them and the appropriate responses and follow-up and investigation.
Yes.
I'm sure our
our-
team has thought that through and
Yes.
there's a plan in
Our
place.
tip line is going to be voicemail, and it will be checked on a regular basis by the staff currently at Plain Ridge Park. And
Your staff?
Yes.
Okay. And there's a procedure to log?
Log it.
Follow
forward it.
up.
Yes.
Okay. Thanks.
Bruce, is there a way to suggest certain information would be helpful to somebody thinking about filing a text, like where you might have seen it in, I mean, how can we kind of prompt them to make sure that information?
We have a
is included?
form on our site that fills out and requests specific information if possible, like a gaming table, the casino, a slot machine, and it's also stated on our voicemail for the phone
Okay,
website.
great.
Is there any practice now, Bruce?
Is
Any
there-
organized practice now in this regard?
There is, to some extent. We have gotten some tips via email and so on our other various sites, but this kind of structures it in a much better way, and we plan to put these kind of signs around the back of the hallways in Plainville, at the casinos, and also near the entrances, as well as eventually we're going to have this information printed on the back of the gaming agent's business cards, so when we give it out, that information is readily available to everybody. I've found in other jurisdictions that probably about 60 or 70% of the information you get are from employees or patrons that have seen something on the floor, don't want to directly get involved, but would, give you a lead that way. And it's always been very beneficial.
It sounds like a great program. You mentioned briefly social media, and I have a 15-year-old that I can only communicate by text.
Yes.
So would this include maybe texts at some point, or?
Elaine would be our expert on that end of it.
Yep.
Oh, over there, sorry.
Yeah.
You're still back there.
That's something that we could potentially expand
Yes.
to at some point.
Okay, well,
Maybe we can just, once we start this and see where it goes and what people tend to use most. And
Okay.
thank you. Looking forward to that.
As usual, this looks great. I mean, I like the design and everything. It would have been ideal as a matter of principle to see this in draft. So we had a chance to brainstorm. We might have had there actually been a couple of thoughts here, and I had a couple of thoughts about it that maybe would have added to the content, maybe wouldn't have, but just for future reference.
Well, we can also modify these.
Yes,
It's not
right.
as
It's not
if these
set in
signs are
stone
out
or-
there, so that was part of the reason for coming towards the commission and not just going off and doing this on our own, was to get feedback. So if you have any comments on that, these are all sort of,
It's all mock design.
this is more the.
But I thought
the
these were all
draft.
printed, these are
We have
pretty.
some.
We have some, not
Okay.
all
Yeah,
the
mock
signs yet.
designs for review.
Yeah.
Okay.
So that was the purpose of the presentation.
Well, it's a
to
great
also
mock
be-
design because it looks very official,
Doesn't
and
it?
and it looks wonderful.
Right. Well, it's like all of our design stuff, I think, is really good.
Yeah, really well done.
Well, so let's just, so if the language, does anybody have any thoughts about the language, if that's in
Well, I'm
play?
curious, what are the the title Fair Deal. Where does
Uh,
that?
We can
where-
attribute that to supervising game agent Burke King. And I told him there'd be no royalties associated with that name.
I was trying to remember, we had FDR's New Deal.
Yeah.
And was it
Somebody had a fair deal.
T. Roosevelt
Teddy
Fair Deal?
Yeah.
I think.
Could be.
Square Deal.
I suspect gaming agents may not quite remember that, sir.
Burke has a birthday coming up. He's old enough.
I like the concept. I did see an earlier draft, and frankly, this is much more professional. I mean, it's just the changing around of where things were located, and I think it'll be beneficial. We do want to. We've made a commitment to keep it safe and secure, and tips are one way of ensuring that.
Thank you.
You're going to have this in the Game Sense area as well?
Yes. We've already discussed it with Penn. They're on board with putting it wherever we need to put it, so.
Mr. Chairman, would you want us to have staff just circle back with each of the commissioners one more time before we finalize?
Well, if people don't have any thought, I mean, if people don't have any thoughts, it's superfluous. You know, the thing that I was wrestling with was sometimes, you know, in doing something really well, it becomes so subtle that you lose the, you know, this is for tips, you know, this is for tips on problems. And, you know, by calling it something, which I love in a way, the fair deal really makes a lot of sense. And then there's some sort of nice text about the purposes and the policy objectives and so forth, but is it grabby enough to, you know, to make sure that the casual passerby is going to realize there's a tip line, you know? I wouldn't debate the point that, you know, I might have thrown that out at an earlier phase, but, you know, we can try it for a while and, you know, give it 6 months and see what happens, and if nothing much is happening, we could always try a different text, and, so I don't have any strong feelings. I think it looks terrific. Any other, you've mentioned the social media.
Yeah, well, that's, as you were saying that, I was just thinking, you know, maybe there's of course many iterations of these that could be simplified. Twitter, Facebook posts that where all of this verbiage could be summarized into something like, think you see a problem, call, or whatever. Or
Matter of
you know,
fact, we've already gotten one
something
tip
to that
via our
effect.
Facebook page.
you know.
Yeah, and that's just it, we hadn't yet made these into smaller digital images and things like that, because we did want to have this conversation first before we finished all of the collateral. So if there were any major changes to this, it made more sense to hold off on that.
Yeah, I think that a phone call is, people think of that as confidential. I don't know if they would think the same thing with a text and/or a Facebook page post.
They sure do.
On the site, you can
Twitter.
print a form and also mail it if you know, don't have to
Well,
put your
I had
contact information on it.
More to a tech question, you know, saying it remains anonymous, how is it possible to send an email
Yeah,
and keep
it's-
that anonymous?
It's not totally,
Yeah.
you know.
Well, meaning,
it says
we
you-
can preserve their anonymity.
right.
So,
Yes.
and we've had that conversation already, so.
And it says you may remain anonymous. Not sure what that means, but it doesn't say you
Meaning
will,
at your request.
I guess, yeah,
Um,
right. Right.
Well, I think the most important thing here is to have the phone that includes tips.
Yes.
Go to a place where we can, you know, check voicemail, and you know, to have the overall title of the program, you know, fair deal, that where we can have a number of.
Yeah. We already had the phone line set up, so.
Where did the tips, do other people use that, or did we just apply for it and get it, or?
So we spent a lot of time on that, and that was one of the things. We were trying to get 1844 fair deal, but just from developing previous crime tip programs like this, we knew that it was really important to try to get something memorable. And
there is a lot of access to 8477, depending upon what the combination of the first, the numbers would be. So we went through many numbers
Oh, really?
to get this one, yeah.
Great, that's terrific.
So, Mr. Chairman, is your reservation about this that the TIPS feature of it is not prominently enough represented graphically here?
Well, that's sort of that's an intuitive feeling I had. As I said, I wouldn't.
So it'd be like fair deal, quote, and then underneath that, something larger, tip line, or?
That was what I was getting at, but, I'm reluctant to get into those kinds of debates because it's so subjective. I throw it out there as a thought.
We did change the initial concept to make the contact information much larger.
Yeah.
For that very
Well,
reason.
integrity tip line
Yes.
stands up there,
Yeah.
Yeah, and then tips and bold gold
Yes.
letters right below it.
but that was what I was getting at.
I like the whole thing. I mean, that aside, I like the colors that are our logo. It looks official. And
We did, and I just want to make the point too, that when this was first brought to my attention, and when the IEB was first starting to think about this, we did do a lot of research in terms of seeing what other gaming control boards were doing, et cetera, et cetera. Basically, what I had found in some of my research is that other gaming control boards, although there might be requests for patron complaint forms, things like that, no one was doing anything as branded as this.
Really?
Yeah, I found that some of the lottery agencies were actually more aggressive in that. So although some of them were doing something like this, no one had anything as branded as this. So,
Have you thought about putting some of these over on the racing side of the house?
All right.
Have your
Anything else?
gaming agent come in next time.
No, thank you.
Yeah.
That's excellent.
Thank you, good work.
Thanks.
Great. Thank you very much. I believe, if I'm not mistaken, that we are completed. Any other business? Do I have a motion?
Move to adjourn?
Second.
Second.
All in favor?
Aye.
Aye.